Welcome back. You're watching the India Development Debate. Every day we celebrate the rise of startups in India and the frenetic pace at which startups are turning unicorn. Among these, consumer internet companies are at the top of the crop. They have changed and revolutionized the way many Indians shop, the way they order their services, and yes, they have given ample and huge opportunities for employment to a whole set of people, creating, in fact, a new category of gig workers. Now, it's not come without debate. The question for a while has been, are gig workers getting fair treatment? Is the relationship between gig workers and the platform one of vendor and company or employer and employee? Gig workers have now gone to the Supreme Court and demanded better rights. They want, in fact, things like pensions, gratuity, maternity leave, and all the other rights that unorganized workers also get. Their argument is that they are being treated as employees and thus must have those rights as well. The Supreme Court today took cognizance of this petition and has issued notices to the central government as well as to large companies like Ola, Uber, Zomato and Swiggy. My colleague Abhimanyu has more details.
The petition filed by gig workers wants cash transfers of rupees 1,175 per day for app-based drivers and rupees 675 per day for others till the 31st of December or till the pandemic subsides, and wants recognition for all app-based workers as unorganized workers as per the Unorganized Workers Social Welfare Security Act 2008. The PIL claims that Uber, Ola, Swiggy and Zomato give contracts of the nature of take it or leave it and seeks health insurance, pension, disability allowance and maternity benefits for all gig workers. Citing a UK court order which had classified Uber drivers as workers, the petitioners have accused apps and big companies of exercising full supervision and control over their manner and method of work. Having been defined in the Labour Code for the first time, over 2 crore gig workers have already been registered on the central government's e-Shram portal. However, they remain outside the ambit of the Contract Labour Regulation and Abolition Act and the Employment Compensation Act. Technically, a gig worker engaged with a company can also work with another company as none of the contract binds him or her. However, gig workers have claimed that commissions to app-based delivery personnel have declined from around rupees 50 per delivery to rupees 20 per delivery.
The next hearing of the case in the Supreme Court is expected in January. But in the meantime, the bigger debate remains, and that's what we're attempting to thrash out today with different voices. To speak on this, I'm joined today by Indira Jaising, senior lawyer of the Supreme Court and representing the petitioner as well in this case. Rituparna Chakraborty, EVP and co-founder of TeamLease, is joining us on the show. I'm also speaking with Lohit Bhatia, who's president of Workforce Management at Quess Corp, and Ganesh, who's of course the promoter of Bigbasket, Portea Medical and many of these companies in the consumer internet space, and understands the other side of this debate perhaps. Welcome to all of you and thank you so much for speaking with us right here on the India Development Debate. Ms. Jaising, let me begin by getting your overview on what gig workers really want, because the whole concept of the gig workers or the gig economy worldwide are people who are masters of their own time, who log in when they want to and log out when they need to. Why then would they want to change this into a situation where they are now marked as unorganized workers? What really is the essence of their demand?
Right. So if you read the petition, you'll find that there are two issues mentioned there. One is a declaration that they are workers. I'm sorry, what you said was that they are masters of their own time. They are not. We are relying on a judgment of the Supreme Court of the UK, rendered in the case of Uber, where the agreements which are signed by the drivers and the company are identical. As you know, they are identical worldwide. And the court has held that notwithstanding that they are quote unquote masters of their own time, entire supervision and control of their manner and method of work, the charges that they can make for each drive, the amount that is ultimately remitted to them, the number of hours that they have to work, the penalties they suffer, the warnings they suffer, having regard to the concept of supervision and control which an employer has over an employee, they fall within the definition of workers or employees. We rely heavily on that judgment, and we request the Supreme Court to give a similar declaration that they are workers under all established labor laws. And if we succeed in that, then they come to be governed by all social security laws which govern other workers. Now, what we have said is that what happens in the interregnum? In the interregnum, there is a law known as the Unorganized Workers Social Security Act. And we rely on the definition of unorganized worker. Now, when you rely on the definition of unorganized worker, you are not arguing that you're not a worker. You're saying, I am a worker. But according to my employer, the Schedule 2 laws, which is Provident Fund, ESIS, maternity benefits, do not apply to me. Now, you may be aware, obviously, that Zomato, which issued its IPO, specifically said in its issued document that these people are not workers. And when they received a notice from the Provident Fund Commissioner, they replied to say, we are not covered by the Provident Fund Act. Hence, we are not willing to pay Provident Fund to our workers, right? And so here are companies which deny social security to these workers, both under the informal sector and under the formal sector. So what we argue is that what is denied to these workers is fair and decent conditions of work. It amounts to exploitation of labor. And Article 23 of the Constitution of India is attracted, which requires that all workers be given fair and decent conditions of work and that their labor not be exploited, which is why we have made all the companies which own Uber, Ola, Swiggy, and Zomato respondents. Today, the court has issued notice on the petition, and I say no more because it's up to the court to decide. And since I am arguing the matter myself and the matter is sub judice, I wouldn't like to say anything more than this.
Sure. No, I understand that perfectly, ma'am. The idea is to understand the broader debate because it has been going on for a while, even before the Supreme Court took cognizance of this PIL. So, Rituparna, if you would like to go first, because we have spoken about this earlier and you have made the point that putting a lot of burden of compliance on these companies would wreck the entire business model. The other side of the argument clearly is that you can't build a business on exploiting people. What would be your view in this debate?
So I have always maintained that let's not attack the very premise on which some of these business models have been built, because they have made their down payment in moving a lot of youth in India today from precarious condition, informal work, to a work of dignity. I mean, obviously, that can be debated and argued at length about what happened to some of them during the course of the pandemic. But if you remove that as an accident, we all realize that it has offered immense flexibility. It has brought in a lot of job market outsider into the ecosystem of being able to offer themselves as service, their time, and maximize their gains from it. Having said that, I do understand that there are situations which deserve the necessary empathy towards the plight of some of these segments who got honestly much more affected than probably the other gig workers. It's very important to bring to light the fact that by definition, gig work is such where there is no employee relationship. And I think that has also been suitably defined and articulated even in the labor code. However, it needs to be appreciated that there should be some kind of exigency fund that we should commit ourselves to. And I think one of the things that I would like to bring forward and request an immediate intervention, that the rules that had to be notified around the labor codes, which actually gives significant and well-balanced, if I may say so, protection for the workers, should get notified. And if that happens, I don't think we need to resort to the extremity, which actually questions the very premise on which some of these business models exist today. I don't think we should push the button in terms of moving to that level, but we would be able to create the necessary safety net, notwithstanding the need for flexibility upon which such models exist. So that's my limited point of view. I think over-regulating something like this in a country like India, where 90% of the workforce is informal, it's premature. Yes, we should have a lighter touch of protection, but we should not overdo it.
Okay, so let's come down to specifics of what we are talking about when we say protection, when we say social security, when we talk about exploitation. And Ganesh, I want to bring you in here. So some of the specific things that I'm lifting from what's in the petition, and this has been a long-standing demand, honestly, on social media as well. So things like pension, things like maternity benefits, things like that. Do you think it's feasible or fair or necessary for consumer internet companies who actually function on the backs and the shoulders of this army of gig workers to provide this? Does it fit into the business model as it stands today?
Yeah, so this has been a debate not just in India, in Europe, and you had Uber in California. What has really happened is, with the digital economy, the concept of work, workplace, and worker, all of them has undergone tectonic change. Obviously, the COVID has also increased the demand for such gig workers. So it's obvious that our earlier laws, earlier systems, earlier protection did not provide for it, because it's a new world where it has changed. So there clearly, I don't think there are two sides of the story. There is only one side. We need to come together to be able to solve, whether it is the government, whether it is the platforms or the aggregators, and the workers and the people who are representing the workers. We need to solve for it. Okay, right? At one extreme, whether it is really disguised employment going off as gig working, or is it genuinely gig work, needs to be defined. And the European Union has come up with 4 or 5 distinct status that define, is it really employment or is it gig work? That is one part of it. 2, what the gig workers are asking, many of it is not only just legitimate, they are very basic, whether access to restroom facilities, access to accident benefit. That is very basic and needed. They are not even talking about more than minimum wage and all this stuff. We are talking about basic facilities. There, the need to provide for this exists. Now, how much of it can you burden the company with without throwing the baby out of the bathwater, killing the particular business model? Is very important. Do they deserve, do they need, do they require health insurance, accident insurance, pensions? Absolutely, yes. How do you provide for it? With the help of government, with the help of a fund, with the help of taxes, with the help of contribution even from the aggregators and platform, is a thing that we need to work out. What we should not do is kill this gig economy, because it is that there is very clearly a need for self-employed people. At the same time, the company should not abuse gig economy to make permanent workers as contractors so that they are able to avoid benefits.
No, but look, so again, Sure. So again, we're talking about these terms, about self-employed or not employed. You're talking about access to restroom and accident benefits. What they're asking for is wider things: health insurance, pension, disability allowance, maternity benefits. Before I go to Mr. Bhatia, I would like to give Ms. Jaising an opportunity to respond to some of the comments you've heard so far, ma'am.
Yeah. So first of all, as we know, the code, the Social Security Code, has not been brought into force as yet, and for good reasons. it's not just because the rules have not been framed, but it's also because there's huge amount of resistance from the labor movement across the board. And part of the resistance comes from the complete obscurity around definitions in the code. It also comes from, for example, there's no clarity on who's a quote unquote a platform worker and who quote unquote is a gig worker. Both definitions are different from each other. The second objection to the code comes from the fact that there is no mandatory provision in the code for schemes for, as you pointed out, disability, provident fund, gratuity, and maternity benefit, which exists under existing laws. So not only do the informal workers lose out under the new code, so do the formal workers. What is guaranteed to formal workers under existing labor legislation is discretionary under the code. So we are not going to see these codes coming into effect very soon. Where does it leave us? Or both your previous speakers have mentioned the need, the necessity to provide social security to gig workers. Let's forget labels, whether they're workers or not. As I told you, that's an issue for the court to decide. Courts in Paris, courts in the UK, courts in America have already held them, as the previous speaker pointed out, to be a disguised form of actual employment. But we can let the court decide on that issue. The immediate issue at hand is, what are you putting on the table for these workers in terms of these very, 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 very real benefits? Now, here's where the concept of decent conditions of work comes in. Somebody mentioned not even having a toilet. That's an extreme example. But I would say not having accident insurance benefit, health insurance benefit, maternity benefits, a lot of gig workers are now women, is also a denial of decent conditions of work. And I don't think any business model has any right to exist if it cannot guarantee decent conditions of work. There is one thing I'd like to point out. In November 2020, the Motor Vehicles Act was amended, and it states very clearly that every aggregator, now you have one more definition. You have multiple ministries dealing with this issue: information and technology, electronics, labor, consumer. Who is responsible ultimately for the plight of these workers and regulating them? No matter how minimally you want to regulate them, who is responsible? We don't have any answers. Let me give you the example of the Ministry of Surface Transport, which amended its rules in 2020, November, and they said every aggregator must insure every driver in a sum of rupees 5 lakhs. Has that been done? No. Term insurance must be given. Has it been done? No. And a very, very important provision in that statute, which talks about transparency. This is how it reads. It's in its operation, including but not limited to functioning of the app algorithm, proportion of the fare payable to the driver, incentives given to the drivers, charges received from the drivers, and such other information as may be notified by the state government by making disclosures on the aggregator's website and app, and updating such disclosures as per requirements of law. Has it been done? No. So what are we talking about? Which business model are we talking about? If you're suggesting that a business model, simply because it has to make profit, can exploit workers by not giving them decent dispute model, and that business model, and the sooner we see it go out of existence, the better for us. So yes, the previous speaker had the good grace to say that what needs to be done is for all of us to sit across the table and ensure that these people have decent conditions of work.
Amanna, may I come in?
Yes, please come in.
Yeah, no, I think this is taking this to one extreme. I appreciate that it's being argued in the court, and it's one point of view. There genuinely need to distinguish between a platform business model, which is a platform that connects two sides, demand and supply side. They are giving discoverability for the worker to get a work, whether it is urban company, whether it is handyman work, whether it's driver work. They are aggregating demand at one side and offering it to people who can, on their own volition, choose to pick up that particular task and then work. That is the platform. I do agree that we should not allow companies to disguise regular work under the guise of contract work and avoid the benefits. At the same time, to say that the business model should go out is not right, because in the digital age, you have the ability to be able to connect two sides, the supplier and the buyer, and therefore make money. And that is how the employment is getting generated.
Sure.
Please
Sure.
don't throw the baby out of the bathwater. So this is exactly the problem that has happened, and it has happened in Europe.
Let me get to Mr. Bhatia. Let me get to Mr. Bhatia. We've not even heard from him yet. Mr. Ganesh, just hold that thought. Just hold that thought. Let me get to Mr. Bhatia. I've not even heard that. Just one rejoinder to what Ms. Jaising said. They talked about the companies making profits. Just as an aside, most of these companies are not making profits. Their business model is not yet profitable, and they're valued in a very different way by investors.
No, the model is different. The model is not to
story. Mr. Bhatia, where would you like to come into this very interesting debate? Sure. Mr. Bhatia, where would you like to come into this very interesting debate where you're dealing with both sides, aren't you? Dealing with the companies and you're dealing with the employees as well.
Thank you, Tamanna. And first and foremost, I must say that all the panelists, while they may seem that they're on different side of the aisles or table, they're in as many words probably speaking the same thing, but probably going for a different direction to reach the same destination. Now, what I'm trying to say here is everybody says that gig workers is benefiting everyone because it's giving freedom of choice. It's also giving freedom of employment. And I think the most important collective bargain that we can give to people is choice. In the last couple of years, gig workers have come in a new form of employment. We didn't have this more than a decade ago. However, most of our labor laws that we made were made in 1948, 1962, 1971. It dates back to even information technology or IT industry being even there, let alone gig workers or platform workers or platform companies itself. So today, first and foremost, I think we must recognize the fact that there is a law which has been approved by Parliament, which is our Labor Code 2020. Within that, there is the Social Security Code. If you read from the Social Security Code, you will see that the platform and the gig companies are asked to give 1 to 2% of their gross merchandising value or up to 5% of what is paid to the gig worker or to the person who works with them as a freelancer. Yes, I completely agree. Ms. Jaising is absolutely right that the rules have not been drafted. But if you just do one quick calculation, on an average, if a gig worker is taking home anywhere between 15 to 25,000 a month, let's assume, that's what we hear from most of the drivers, and much higher than that, 5% of that will translate into almost 1,500 rupees a month. If you were a staffing employee, your social security that you would be contributing would be near about the same amount. So the point I'm trying to make is we should probably spend more time to understand where is that 5% or maybe 1,500 rupees which gets contributed each month from millions of people. What does it get them? Does it get them these benefits of disability allowance? Does this get them the benefit to their family on death allowance? Does it give them insurance? Does it give maternity? Because let's understand one thing. While we all agree on this panel that yes, in every form of employment should give, let's say, maternity. If it's a gig worker, let's ask ourselves the question, how will it be given? Because the true form of gig could be that the same worker is working on at least 3 to 5 platforms on the same day. Would you split maternity by number of hours that the person worked with the employers or the different platforms? I think that question needs to be answered. So we've come quite far with the labor code. We've come quite far with the Social Security Code 2020. If we can ask the government the question, and I hope that this court case actually does that, ask the government what is the intent with that 5%, where will this money go, who will create the corpus? Whether it will be NPS, EPF, or anybody else? How will the workers benefit out of it? I think we will definitely have the answer to what we are looking for today.
Tamanna, can I come in and add a few bits
since it
before you wrap up?
seems to be on the face of it 3 versus 1, I'm going to... Okay, I have very few minutes left, so I request you to do it quickly, Ritu. Please come in.
I mean, I'm a big fan of Ms. Jaising, so it's like a fangirl moment for me to be in the same panel as her. But ma'am, my only submission to you is that you are in a position in this country where every word of you makes a huge difference. And I would urge you that even if with due reason and sufficient work, if you suggest that these business models should die, I would really ask you to reconsider this, because personally I have spoken and I've met, and this is my job, this is how we make our living, where some of these kids are youngsters who are doing colleges during the daytime, and in the evening they are trying their best to kind of give themselves a source of earning and a livelihood. Some of them I've offered a permanent job and they have very confidently denied, because they feel that these options, they can work 15, 16 hours when they are young and they can maximize their earnings. So I do think we should sit down, like Mr. Ganesh said, like Lohit said, in terms of coming out with a touch of empathy and humanity. However, we should not by any chance try and kill this business model, because it has brought out many kids from precarious life conditions. So, ma'am,
I think that was a qualified statement. I'm going to give last word to Ms. Jaising, because I'm completely out of time and I just have a minute and a half for her. So, ma'am, I'd like you to give your response. I just, by saying, I think you were giving a qualified statement. If it's going to exploit people, then let's kill the model. Is that correct?
Yes. So first I want to thank Rituparna for the amazing compliment that she's paid to me. I do wish I had the convening authority that you attribute to me. I don't. Well, fortunately, the government of India, through all its various ministries, is a party to this petition. And sure, they will be called out. Sure, they will be called upon to answer the questions that have been raised by some of the panelists here. It's an expert job for an actuary to decide what would be the final outcome of this so-called contribution that they're supposed to make. I did not say that the business model should die. All I said was that every business model must ensure fair and decent conditions of work. It's a debate which has never taken place in India. We as a country do not respect labor. Let's admit it very candidly, okay? It's time for workers, whether they are independent contractors or whether they are formal or informal, they are still workers. They are giving their life and blood for people like you and me. It's consumers who need to wake up and say, look, they're providing such a valuable service. And this should have happened during the pandemic. Why were they not declared frontline workers? They would have got a lot of benefits. Their vehicles had been confiscated.
Absolutely. Ma'am, I have to end. I have to wrap because of paucity of time. But I think this is a debate that needs to be continued. This is a debate that needs to be continued. Once again, forgive me, I've run out of time, which is why I have to wrap this very interesting debate. I'd like to thank all of you for joining and invite you back again in a few months to re-look at this very important issue again. Thank you.